Welcome to AARP, Arizona Hispanic Connection. Educate. Celebrate. Connect. Arizona Hispanic Connection.
Good morning. Good morning. This is AARP, Arizona Hispanic Connection, with another very important subject. As you know, this is a platform. We have a Facebook page, a YouTube channel, and a radio show, and all bear the same name, AARP, Arizona Hispanic Connection. We really hope that you can join us on Facebook if you are listening by radio, and follow us. We post a lot of good information, videos, etc., on our Facebook page. The subject today is estate planning. You decide. We already did a show on this matter in the past, but we focus primarily on the medical side. When you do estate planning, it could involve both medical and financial. I learned that from one of our guests, of course. And the show then, I believe it was called Let Your Will Be Known. Well, today we want to focus on the financial aspect of it. We work very hard. We perhaps bought a home, 2, 3, have a business. We might have a 401k, IRAs, life insurance, you name it. You might have a lot of things, and you're going, living with no worries. But we should consider what is going to happen with our resources, our assets, when we pass, and not only when we pass. How about if, for whatever reason, we become disabled? Incapacitated, as one of our guests uses that word too. So this is what the subject is going to deal with today. And let me introduce our guest real quick, because this subject is loaded. So we have to get right to the subject as fast as possible. But stay with us. I believe you will learn a lot about what you could do, what are considerations regarding your possessions, things that you own, your houses, your businesses, your 401ks, your life insurance policies. What would happen if you have some assets and you have minors at home? Are there arrangements that you can do for them as well? So let me start. I'll just start from my left. Alejandro Perez. Alejandro.
Good morning.
You are a estate planning attorney, and you own your own firm. Is it a firm of Alejandro Perez? Or,
the law firm of Alejandro Perez.
The law firm of Alejandro Perez. Welcome. You were with us the first time, so I'm glad you're back.
Thank you for having me back.
Yes. And then we have Lupe Solis. Lupe Solis is retired, right, Lupe?
Yes, I am.
I'm proud to. Huh?
Luckily.
So we asked you to come because you worked for AARP for some 10 years, 10, 12 years as an advocacy director. And I know you personally. I know you are an advocate. Even though you retire, you continue to be very much involved in the community. I consider you like a community advocate in many issues. And I know you have something to share also regarding estate planning. So thank you for coming and welcome.
Thank you for having me.
Then to my right, we have Ruth Hernandez. And you are, Ruth, a financial advisor with Trilogy Financial Services?
Yes.
And then we also have Elaine Colley. And Elaine Colley is an author and a speaker. She wrote a book, My Will Be Done. And you, Preserving My Legacy, I might add in. Actually, you have a copy of that book. And so thank you so much, Elaine, for making time to be with us today and help us carry out this important conversation.
Thank you so much, David, for having me. I'm very excited about our conversation that we're getting ready to have.
Perfect. Thank you. All right. So what I would like to propose is that let's introduce some terminology, and I'm going to ask all of us to basically ask questions. If I'm not addressing a question, go ahead and address it yourself. The whole idea is to paint a picture to the audience, to ourselves, if we haven't done estate planning like I haven't done it yet, and as to what this is all about. So the first question or concept that I would like us to explain, perhaps we can start with you, Alejandro, is what are we supposed to understand by the word estate, and then what is a estate plan?
Sure. So estate is essentially a term that means your bounty, everything that you own in your life, that you've acquired, your family. What is what is your property? What is it that you own? What have you acquired? What do you owe? That's your estate. An estate plan is it's a misnomer, because the estate plan goes more than just what you own. An estate plan is a plan that is should be detailed, crafted for you specifically, thorough, and comprehensive plan that allows everyone to take the guesswork out of the end of your life decisions. So from when you pass, giving gifts of who you want to receive your property, etc. Number two, and not only death, but number two, planning for incapacity, which is disability. So who's going to make your decisions when you are unable to make your own decisions? Who's going to have the power of attorney to conduct your financial affairs when you're not able to do so yourself? And basically, an estate plan should take the guesswork out of your loved ones, allow your loved ones to either operate on your behalf or mourn your death, but not have to worry about pulling the plug. What would you want to do with your money? What would you want to do? And you definitely don't want the court either to make those decisions. We all work very hard to get what we have, so we owe it to ourselves to direct what we have and how we want things to go.
So it's basically my plan of what I want my assets to, who do I want them to go to, etc.
I tell my clients that it should be like a map.
Okay.
There should be no guesswork in it. It should give you every information you need to get to where you want to go.
Perfect. Now, is it correct that when you talk about estate, it involves different documents within the estate plan? So it's not just like one page or one concept, but there could be several legal documents within a estate plan.
Right,
correct?
depending on your particular needs. That's why it's very important you see an attorney, not try to go through this yourself, because every person has different needs and every person has different goals and objectives. I think a unanimous goal is that the courts not be involved and take money from you upon your death, which is what probate is, which we'll discuss later, I'm sure.
Right, right.
The estate plan is different documents such as a trust, a will, beneficiary deeds, warranty deeds, depending on what you need. If you have special needs or incapacitated adults or children you care for, naming those people, doing special trust needs so that their Medicare and their access to funds from the government is not conflicted. If you have children, guardianships.
So pretty much everything.
It should be, like I said, it should be thorough to where it leaves no question unturned, and it should be so done to the detail that there's not really a need to change it as you go further.
Right. Now, Elaine, you wrote a book and you focus on basically giving like a list of things that people need to be concerned with and need to take care of. What does that entail?
Actually, it's like a puzzle. And so what I recommend, and you follow the book, you're taking the pieces of your life and you're laying a roadmap so that when you contact the professionals, they have everything they need to assist you. There's no guesswork involved. Because what they don't know, they can't help you with.
Right.
So it's basically bringing all those pieces of your life together, right? So that when you contact and you say, oh, I need help looking at how I'm going to pay for this. Well, when you take it to the financial advisor and you know what your plan is, then they can better assist you.
Right. So basically you prepare people to see the attorney in a sense.
To see all the professionals.
All the professionals.
There's a lot of professionals that are connected with you leaving a legacy.
We cannot hide this. This is a very complex or could be very complicated process. And Ruth, you are a financial advisor. From your point of view, do you take into account the estate planning, present, future, as you advise people in managing their finances?
Absolutely, yes. The estate planning component is definitely, one of the components of a true financial plan, of a financial plan that is in good order. I must say. So yes, we do look for different things when we do meet with the client for the first time. We always ask if they have a trust to begin with, and if they do not, and we notice that there's certain triggers that really where we actually recommend our client to have a trust, and that is if they own property first and foremost. You want to avoid that property from going to probate. So yes, we do look for key factors to recommend our clients to.
So the advice would be a little different if they do have a estate plan as opposed to if they don't?
Yes, in the case that they do have an estate plan, we have seen horror stories, with estate plans that were not completed correctly. So we always do recommend that they get it, revised, and we can refer them to our current estate planning attorney just to have a revision of their plan and make sure that everything is in order, or if it needs to be updated, because many times the HIPAA releases and things like that, they become outdated after some time. So.
Do you see a lot of Latino clients or not too many as a percentage of your clients?
Yes, the 90% of my clients are Latinos.
Good. That's excellent. That's
Yes.
excellent. Thank you. And Lupe, before we go on our first break, I understand that you have gone through this process of estate planning. Does it feel different before you did it and then after you did it?
I believe there's a certain peace of mind that comes with it. And, we have 3 children and grandchildren. And one of the fears that you always have is that by going into probate, you might essentially be reducing your estate by sometimes as much as half.
Wow.
The other issue that people don't often think about is that upon death, there might be disagreements amongst the siblings as to how to handle things. And this is an exact way to say, this is what we want done. I've gone as far as to make a listing of jewelry, and not that I have that much, but I have some pieces that were my mother's or my grandmother's.
That is amazing.
And you just, you treasure them. So you know that some of them are going to like it more than others. So I made a list. I said, this goes to this person, this goes to that person.
Right.
Now, you can't always plan for everything, but you try your best to leave your affairs in order.
Mm-hmm. Now, we have heard many cases, many cases where there's fights among family members because nothing was done, and they are guessing and fighting and this and that. So obviously it is critical. Do you want to be very brief? We have to go on our first break. 30 seconds. Do you see that in your work, Elaine?
I do. I see that quite often, but I tell you that when you have a plan, all that is eliminated.
Good.
It's just eliminated.
Right.
So all the stress, all the fighting, all the tug of wars is done.
Right.
When you have a plan.
Right. Now, Lupe, 10 seconds. What is it? Is it time consuming? A lot of energy to get everything in order to do the estate plan?
I suspect that it depends on what you own and how much you own.
Okay.
Yes, it does take time to put not only your papers in order, you have to try to remember everything that you should remember that should be included in there, especially if you own, for example, more than one house or something like that. But it's worth the trouble.
Right.
And once you have it together, what we found was that our lawyer gave us a list of things we needed to consider. And she said, depending on how long it takes me to go through your paperwork is what your cost is going to be. So it pays to be prepared.
Right.
And
Thank you.
we did.
We are going to be getting into the nitty-gritty of estate planning. Stay with us. This is AARP, Arizona Hispanic Connection. We'll be right back.
Welcome to AARP, Arizona Hispanic Connection. Educate. Celebrate. Connect. Arizona Hispanic Connection.
Thank you. Thank you for staying with us. This is AARP, Arizona Hispanic Connection. The subject today is estate planning. My wife thought it's state, but no, it's estate, right? Estate planning. You decide. You decide what you want. Okay, let's briefly ask Alejandro to help us understand what am I supposed to be considering when I'm doing this, right? I'm sure that if I'm married, I'm not married, I have children. Who else do I want to be in this plan? And you already told us that there's the issue of also making arrangements in case one becomes disabled. Who's going to act on your behalf? If you have minors, right? Then there's a consideration there, and if there's a person with disabilities also, right?
Yes.
Any other things that we need to be concerned with in terms of how about tax implications?
Absolutely.
Yeah, tax implications. Now, also, are we is understanding the community property state concept important in estate planning in Arizona?
It is important to the extent that you're in a second marriage and you both have separate children, or one party may have no children, other party may have children, because, right, once community property, everything is 50-50. So, everything that's part of the marriage.
So in Arizona, if my wife and I have, say, $100,000, it's 50-50. Mm-hmm. So if I pass away, she doesn't get all 100,000?
If you leave it to her, she
unless
won't get
I make an arrangement. But
right.
If not, then I have to decide what to do with my 50%.
Well, correct. So usually what will happen is if you do not leave it to if you don't have a will, she gets like $29,000 in your example as a offset,
okay.
And then the rest will go to your children.
Okay.
So it can get difficult, and that all costs money,
right?
Because the court would have to administer.
Okay, let's go to the nitty gritty,
sure.
and please, engage, because this is very important. Explain to us what is the difference between a will and a trust. I think this is extremely, extremely important. Go ahead.
Sure. A will is a document that leaves, that directs property to be left to certain people. So it is a way to leave things to people upon your death. The problem with the will is that it has to go through probate under the Arizona statutes. It has to be probated. Mm-hmm. So whatever you have, the will does not own property. So
the will does not own property.
It just passes property.
Okay.
So, for example, I can have a will and I can say, I want my car to go to David. But
it doesn't pass that car to me.
I have to institute a court proceeding. And then once we institute the court proceeding, the court will allow
explain
to
us what probate means, because probate is a concept that I believe it's a little bit difficult to understand.
Sure.
So you're saying I did a will, I just... even if I wrote it on a piece of paper and I had it notarized, it's valid.
No.
It's not?
No.
Okay, so let's just say then that I did it the right way. I did a will, but what does probate mean?
Sure, probate is a division of the court. So there are judges.
Okay.
There's a clerk. You have to probate, meaning you take the will to the court, you pay a fee, and then the court will oversee the administration of your will. The court has to oversee the administration.
So what you include in a will happen, but it has to be done through the court system. Mm-hmm. Which is very complicated.
You'll have to get, for example, letters. You'd have to choose an executor of your will, and that person would have to get letters from the court saying that the court recognizes you as the executor of the will, and then they would have to present that. So it's an expensive and tedious process.
So it takes time. It takes more money. Obviously, you wouldn't recommend it as an attorney?
I would not recommend that be the only thing you have. You do need a will just in case. But the ideal thing is to have a trust. A trust does not go through the court. It's a completely
So let's go
matter.
to the trust now.
Sure.
So you just explained to us a will, and now a trust. How is that different than the will?
Sure. A trust is an entity, meaning it can own property. It can dispose of property. You name, when you do a trust, you name a trustee, which in your life would be yourself.
So when you are living, you still have control of your possessions.
Absolutely.
You are the trustee while you are alive. Okay.
But the possessions are owned by the trust. So your house, for example, would no longer be in your name. It would be in David Parra as trustee for the Parra Family Trust.
Okay.
That protects, your property from creditors, from people coming after you, lawsuits, etc. It also prevents you having to go to probate upon your death.
So is the biggest difference the probate thing? The probate?
Well, and the privacy.
The privacy. So
The privacy.
I understand that when you go through probate, it's a public thing, so everybody has access to
It's a
who's
public
getting
record.
what.
Absolutely.
That's
And I
interesting.
mean, the privacy, the protection, and then just there's no headaches involved. If you name your successor trustee, that person should be able to conduct business on your without having anything else.
So now, Lupe, go ahead.
Well, and I was just going to say that I think it's really important for us to make a point of the fact that it doesn't really mean that you own a lot of property. It means that you've made decisions about what you do have. And especially, I always tell young people, in the case of young people with children, you would not want to leave those children, just because you told mom or dad, you take care of them. If something happens to me, somebody else could come in. The court could decide differently. You really do need to make the decision yourselves. And the best way to do it is not really a will, because that will cost money. It's to do it through a trust.
A trust.
That brings to mind the article that I read in the Arizona Republic on February 18th. Can you address that? The article about the husband having to go to court to get what he needed to take care of his own wife?
Right. So if you don't have documents prepared ahead of time, you have no protection. So in this case, the gentleman's wife didn't have a power of attorney. She didn't have anything in place. So the husband was not able to help her move nursing homes, get her retirement. So he ended up losing, 1/4 of her
So
retirement.
basically, if there's no power of attorney, then the state, the healthcare system will do whatever they have to do with the patient,
Well,
and the
they're-
husband has no say.
They're
in it.
regulated by law as to
Wow.
no one can order them around. So I get calls all the time. For example,
this is very
I got a
important.
call Thursday from a daughter who said, my father's in a nursing home. He's dying, but she thought they were abusing him. She's like, I want to take him out. Well, my first question is, do you have a power of attorney? Wow. No. Well, it's going to take you probably 3 to 6 months to get a guardianship.
go through a guardianship.
Through the court, which
Okay.
costs about $1,500 to $3,000. And
1,500 to 3,000.
correct,
Okay.
just to get, which a power of attorney
guardianship.
on itself would probably be like $250.
Okay.
Yeah.
So because you didn't have a power of attorney, now you have to get a guardianship.
Yeah, and
from
I mean,
the
he
court.
died in the meantime. So,
Wow.
yeah. So, and they wouldn't let her see her father, so it was stressful for her. So she
Yeah,
was
yeah. Any other consideration questions? Because I would like to get in on the third segment into what happens when somebody doesn't have anything. What happens when
Sure.
somebody
One-
has a will, and so on. But let's
Sure,
just continue
David.
with this segment.
One major
Go ahead.
consideration is to pinpoint who you trust and who you want to succeed you. I always ask my clients to at least have 3 successors in mind, meaning if I'm no longer around, then it goes to Lupe. If Lupe's not around, it goes to you, and so on and so forth. And the reason is because when you are planning your estate plan, it kind of puts you in a bad spot. You have to think of, it's kind of like Game of Thrones. You have to imagine anyone that could die has possibly dead at the time of your death. So you have to pick at least 2 to 3 people to step up to the plate because you don't know who's going to be around.
Right. And Ruth, how much does the state plan come up in financial advising? Is that something that it is definitely addressed or not necessarily?
No, it definitely has to be. It has to be addressed because it's such an important part of a good financial plan. So no, we do frequently address it. We let our clients know. We're going to be reminding you. So every review, we bring it up. We're always trying to make sure that they have the right things in place. And if they don't know the correct professional, we're happy to refer them. But yes, it does frequently come up.
Good. Yeah. Okay, so we still have a few minutes. Okay, so there could be the issue of minors in the house that you have
Yes.
to be careful to in a trust, you assign a person to take care of them if
You
you
can, yes.
became disabled.
Right, and then per the statute, the court, that's the first thing they look at is who the parents decided.
And not only to take care of them, but even to basically administer the
money.
assets until they become of age, correct?
And there may be 2 different people.
Right. Okay. So if there are minors, there's this
You
consideration.
know your family. For example, you can say, I want my sister to raise the children, but then you also know she's not good at finances. So you say, I want my brother to administer the finances.
Okay.
So that's just a matter of you knowing your family, knowing all of the things that are available to you. If you leave children behind, then automatically then you have to go through guardianship proceedings, which is another $1,500 to $3,000
Wow.
with the court.
Okay, so then I read.
And not to mention,
Go
I'm
ahead.
sorry to cut you off, but you don't want to put the court in the position of who's going to watch
Deciding,
you. Decide
of
children.
course. That's a key point, because if you don't decide, somebody else is
Right.
going to decide.
And they don't know your family
Right.
as well. They don't know your family as well as you do.
Exactly.
Right.
You know all the secrets and all the things that will make that child a healthy adult. Because
Exactly.
when they're a child, they're counting on us to give them what they need so that they can be a healthy adult. And if we shortcut them by deciding that we're going to let the state and probate court handle it, we're cutting their opportunity to be all they can be.
Right. I watched some videos on these issues, and they use the example of a bucket with a lid. So when you basically do a trust, I learned that it's like putting all your assets in a bucket, and it has a lid that you still have access to everything. Correct?
Right.
As you said, the grantor is the person who does the trust. Correct?
Okay, exactly.
So if I do a trust, I still have. I'm still the manager, if you will, of my assets.
Absolutely.
Correct? And then if I cannot decide, then the trustee steps in.
Well, you are the trustee in the beginning.
Okay, and then there's another one that I appoint.
It's called the successor trustee.
Successor.
Exactly.
Okay, so then that person would step
Becomes
in
the
for
trustee.
me to make the decisions for me if I cannot do it or if I passed away.
Yes.
So okay, in the next segment we're gonna go step by step. What happens if you didn't do this, or if you did this and that and the other? So stay with us. This is AARP, Arizona Hispanic Connection. We'll be right back.
Welcome to AARP, Arizona Hispanic Connection. Educate. Celebrate. Connect. Arizona Hispanic Connection.
Thank you. Thank you for staying with us. We are addressing estate planning. You decide. This is AARP, Arizona Hispanic Connection. We have wonderful guests today. As always, I always say that our guests make up the show. And our shows are great because of our guests. Thank you so much for making time to be with us. Okay, so let's paint some scenarios. Here's a family. Nothing was done. I understand that doing nothing is an option on this. It is an option. Doing nothing is an option. Sometimes you hear that doing nothing is not an option. In this, it is an option. What's going to happen, Attorney Perez, when nothing's done? What happens?
Sure. So the term is the person is considered to die intestate,
Okay.
meaning they did not possess any wills or documents directing what their will was. So then there's the laws of intestacy of where things will go. Of course, that was a very expensive process. Again, you have to go to the court. The court has to deem that the person died intestate, and then the laws of intestacy will apply, which means it will go down. It will be distributed per stirpes, which means to your children.
There's like a hierarchy,
There's a hierarchy.
like in relatives, how close they are, etc.
Correct.
And so the court will basically do its thing, even though you didn't do anything.
Right.
Right. Okay.
But you're looking at a very pricey situation at that time.
So that's also.
And there's no, you have no discretion at that point. It will go to whoever the court sees is in line, to receive your.
Yeah. So we still owe it to the audience to let them know doing nothing is an option.
Sure.
It's not the best option, definitely.
Well, it's not a good option.
It's not a good
advisable.
option,
Yeah.
but it is. In other words, somebody didn't do
David,
anything.
I
Yes.
really would not call it an option. I think it's like doing something or doing nothing. It's not an option. It's just Jews
Well,
chose
Lupe,
not to
the
do
fact
it.
of the matter is that some people are not going to do anything. Even though it's not a good option, people will.
They're so afraid of the cost.
Right. And sometimes it's a process that it's tedious. It's time consuming. It's a lot of energy. I mean,
I found
just
that
like
the
filing
process-
taxes. When you file taxes, it's a process of. So this is maybe 20 times more. So sometimes you kind of put it off and says maybe later.
And it's true. Some of them are afraid of the cost, and that's why it's so important that you have someone who walks the financial world with you.
And I think today, like with, I charge flat fees for estate plans. So, I mean, my fees range. I mean, if it's something, if you just want a will only, that probably $500. And then if you want, but most estate plans are going to cost you between $1,500 to $3,000. And then if you have more complicated scenarios or you need tax planning, because if you have more than $4.2 million in your account, then you're going to need some more sophisticated work.
So
And that's changing with the tax law.
Right.
So somebody didn't do anything. You already told us what's going to happen. So let's paint the scenario. Somebody just did a will. Maybe they didn't know. Maybe that's all they knew. Maybe they didn't have the money. What's going to happen when somebody passes away, and what happens with the children or whoever's in that will? What is the action that usually takes place?
Sure. Well, the will has to be submitted to probate by the personal representative.
Okay.
The personal representative has to be acknowledged by the court, and then the person can conduct business and distribute the money in accordance to the will.
Now, so is the person granted authority to do it, or it's done right there and there at the court? Through the judge.
The judge, even though you name the person, the judge has to give the person permission.
Okay.
So if that's done, right, and the court is in the process of making that decision, and I'm cousin Susu from Oklahoma, and I step in and say, no, that's not right. She left that for me. What happens then?
Right. I mean, in that point, then you're looking at a probate dispute, which can be, hundreds of thousands of dollars.
So even though it's not in the will, there's still some relative can claim.
Absolutely. Oh, that happens all the time. Yeah.
Wow, that's interesting.
Not only that, but there are cases where people die and they think they left a valid will with an executor. And guess what? 10 years down the road, sometimes 20 years down the road, the bill still has not been settled. And that is that happens a lot.
Right.
The person that becomes the executor decides at some point that, well, I'll take care of this later. And the rest of them could be left waiting forever and ever. And I know of at least 2 cases where that's the case.
Okay. So no action, a will, and it goes through probate. It's going to be complicated, messy. It's public. Everybody will know about who got what. And
it's going to take money away from the people that
And then it's going to take money away because you have
it's going to require them to pay the creditors beforehand and proof of that.
Wow.
So it can really drain the estate.
Perfect. So let's go to another scenario. Somebody knew about it, heard this radio show or what have you, and got a estate plan. So now they have a estate plan done, which basically it takes the form, the initial form as a trust, correct?
Correct.
Could we say that the main piece of a estate plan is a trust?
Oh, that's a big part of it.
A big part. So you have a trust. Now, you don't have to go to court. So basically, what happens? You have homes. You have money in the bank. So it automatically becomes yours.
It automatically no. I mean the trustee then administers the trust.
So that means that let's say a house is involved. So then they have to transfer the house to the other person to the person who inherited his name.
Well, the person may not want that. The person may want the trustee to sell the house, and then distribute the money. So it just depends what you want. You can do anything you want to once you have the trust. You can say, I want the house to be sold, or I want the house to go to someone else. If you want the house to go to someone else, then I would advise you probably not to put the house in the trust, or to put a beneficiary deed. So I mean, there's different options. That's why you need to have an attorney to know what those options are. But I mean, the person just doesn't inherit. I mean, it could be, you can direct the trustee to do certain things.
Right.
Can you address the fact that what the trust has to do, if you are a business owner, what happens to your business when you're passing away? How does that work?
Sure. Well, hopefully if you have a business, you'll have what's called a buy-sell agreement with your business that's part of your operating agreement. And in that case,
which I assume you would recommend if somebody has a business.
absolutely,
Okay.
absolutely. A buy-sell agreement. You should have a succession plan for your business. In the law, a business is a person just like we're people, so it needs its own estate plan. You can dispose of your interest in a business through your estate plan, but if you have a business and you want X, Y, and Z to occur, then you need a buy-sell agreement and an operating agreement.
Okay. Yes, go ahead.
Yes, and another important thing to consider is once you do have a trust, I mean, there's a lot of legwork that needs to be done after the fact. You still have to go and start changing your assets into the name of the trust, and I know, our attorney will address that, but on my side of the spectrum as a financial advisor, for the investment accounts, for the life insurance, usually or most commonly the spouse is listed as a primary beneficiary of these these accounts or the policies. So what happens is when they do have when our clients do have a trust, the trust needs to be listed as a contingent beneficiary. This way the trust can mitigate where those assets are going to go, or so that they can be dispersed in the way that the family wants it to be dispersed. Many times if the children, or if a husband and wife have minor children, it's not a good idea to put the minor children as contingent beneficiaries. Let's say if they have 3 children, split it between the 3 children, because that can always cause problems down the line if they are still minors, if the parents were to pass away.
I believe I read something about, what if I name a beneficiary for, say, my 401k? What's first? What has more authority? That aspect of my 401k, assigning somebody as a beneficiary, or the trust?
So if you, the 401k is administered through your beneficiary. So if you name something in the trust, it's not going to be valid. It's going to be whoever's the beneficiary on your account. So I would advise you to have the beneficiary be the trust. As she said, or your spouse with the trust as a contingent beneficiary.
Could you not name a beneficiary for your 401k and just do it? So you have to, actually, that's a requirement. I think you have to in your retirement plan. So just like you put a house, land in a bucket and a trust, are you also able to put businesses there? You also be 401k accounts, life insurance, everything and anything, huh?
Except for IRAs. Are not advisable to place in a trust because of tax consequences.
Okay.
But other than that, most everything else, there's certain things you don't want to put businesses in trusts, but business is a different ballgame. You can structure businesses where an LLC is in charge of another LLC and so forth. So, it can be done, but that's more sophisticated stuff there. But
yeah, we have about 2 more minutes for the break. Please help us understand again, in cases of a disabled person. I have a disabled child. I am concerned that if I pass away or become incapacitated, that somebody's going to take care of my child.
Sure.
What is the process called? How can I protect that? How can I?
Sure, absolutely. Yeah. And that's something close to me because my cousin is autistic and he's never going to be on his own. So in a situation like his, you would need what's called a special needs trust.
Special needs trust.
So the special needs trust, what that does, it is because if he were to receive $200,000, $50,000, that's going to exclude him or her from receiving their entitlement benefits through the Department of Economic Security, through Social Security, through Medicare. And you don't want them to be affected in that manner. So you have the special needs trust in place, which gives them money. It will be considered as income for tax purposes, but it will not be considered income for purposes of Medicare, Medicaid, and benefits.
That's amazing. So this person doesn't have to lose their benefits because
Absolutely not.
But now, if they just did a will, then it would affect them.
Right. If you do a will and you leave 100% to your child, and the child doesn't know how to administer that, that's negligent, because at that point they're not going to be entitled to any benefits, and those benefits are going to, if he's going to have to pay, he or she will have to pay out of pocket, it's going to drain the whatever money they have.
How are you able to protect your assets against people coming after you, lawyers, whatever? Even if you do ever use long-term care and Medicaid, who long-term care basically provides, like, say, nursing care. can they come after you? And if they, I'm sure they can, but are you able to protect those so that they don't come
Sure,
after
trust
you?
is a great vehicle to protect your assets from lawsuits from third parties, and of course, so is insurance. But a trust provides you that protection that it's no longer yours per se; it belongs to the trust.
Got it. Thank you. We have to go on our last break. Time is flying. Stay with us. This is AARP Arizona Hispanic Connection, addressing today estate planning. You decide. We'll be right back.
Welcome to AARP, Arizona Hispanic Connection. Educate. Celebrate. Connect. Arizona Hispanic Connection.
Thank you. Thank you so much for staying with us. This is AARP, Arizona Hispanic Connection. Wow. Very loaded subject.
Lots of stuff.
We're going fast. But what our purpose is to just kind of paint a picture.
Sure.
Give ideas of what it entails to do. Right. Remind people of how important this is. And then, of course, after that, you have to do your homework. You have to talk to more people and then go to a professional. Go whoever you'll trust, whoever's going to help you. And now, Attorney Perez, there's also other areas that a trust protects you against. Can you
Trust will
address
protect
those?
you against anyone that can come after you for money. So creditors, if you owe creditors money, they can't get to the finances that are in the trust. So everyone is limited to whatever money you have that's outside of the trust. That's why you have to be very careful to put things into the trust. The biggest mistake I see is clients will leave my office and I've told them, they've signed a letter saying they understand it's their responsibility to place property into the trust. But then when they pass away, I find out they never placed the home into the trust. So it's incumbent upon the client to actually make sure the trust, and I give them the deeds and everything, so there's really no excuse for it. But
Good. Look, a little bit more on your experience so that the process of doing it. I mean, was this like a half a year, 2 months?
No,
Just
if
give us some ideas.
unless you're extremely wealthy and you're not administering your own things, you probably can do that in a week's worth of time of sitting down and just writing down everything you want to make sure not to forget, to include in there. But the other piece about that is that once you sit with your attorney and the trust is done, you do have to file it not only to change your property liens, but also with your banks and also with your financial planner. Make sure that they know. And I think that Elaine is going to address something about who should know about it.
In the trust, you really don't want to share with everybody. Okay, you're getting the car, and you're getting the TV, and Susan, you're getting this, and Jack, you're getting that. The trustee that you put in place would disperse anything that you already done. And the reason being is because you're still the trustee while you're alive, right? And so you have the opportunity to change your trust. Will you address that?
Right, a lot of things, right, you can say like, I'm going to give you my car. Well, the car might not be around anymore because you may have gotten a new car. You may have sold your car. You may not have that property. You may have changed your mind. Right, you can always make changes. It's not advisable to tell everyone, here's the contents of my trust and here's who's getting what. It's not really their business. What I do recommend is they say, the trust is located here. When the time comes, if you were to come to me, I give you a binder. The binders, put it on a shelf. Keep copies in a safety deposit box or a safe, and just relax.
Right.
And keeping it in the cloud. I call it in the cloud because we all know that there's things like fire and water damage.
Absolutely.
And so investing a few dollars to scan it and keep it in the cloud.
And I keep all my clients' estate plans, in perpetuity. I don't dispose of them. They are on the cloud. So I always tell them they can come to me and get it again. And, I offer once a year I try to send out a newsletter, any changes in the law.
Yes.
That's something you also have to pay attention to, especially now we're in a new administration. Things change all the time. So right now, the threshold for estate gift tax is $5.4 million.
Let's address that because I think we don't want to go too fast. So there is a gift tax, right? Can you address that again? $5.49 million that I'm able to give and even to inherit. I can do it being alive or being already having passed. That I can give up to 5.49 throughout my lifetime, without any tax implications on the gift tax.
That's right now. I mean, it's
it could
changed. It changes. It's been as little as 100,000.
Because that's important. I mean, maybe most of us might just have, I don't know, 100,000 or so, whatever.
Maybe.
But what if somebody's in the millions? They have to be concerned that if
that's when you need to get a team of people with you. And I want all of my clients to have a team, because I tell my clients, as an attorney, you're just not an attorney. Like sometimes I think I'm a counselor, a psychologist. So I have to explain things to my clients. You don't want to disinherit your daughter just because you're mad at her. But in addition to that, I always tell them you need to get a team of people around you, and that ideal team is a financial advisor, a CPA, and an attorney,
right.
And then whatever else you need, someone, because I don't know tax law like a CPA is going to understand tax. I'm not a tax attorney. I don't know about making investments. Your financial advisor knows about making investments.
Right.
So it's
we
good
need
to have
do
that
a
team
show
in place.
on the tax implications of all this. I think it's important. Yes.
That is important, very important.
So again, the 5.49 million is throughout your life, and you can and whatever you do between now and when you pass, it'll be counted. So it's being counted, and I believe you can give up to $14,000 a year to I believe a relative, anybody, and I think it would be double. Well, if you have a couple, you can give 14 to each of the couples, and that with no tax implications. You don't even have to.
For you, the giver.
Right, for me, the giver. You don't even have to report it. Once it goes over 14, then you have to report it.
Right.
There's a form that you have to do.
But the person who's receiving it counts as income towards them.
Right. And then again, the $4.49 million that the government allows us to gift. Now, what is it called before you pass and then after the pass? One is called the gift tax, right?
And the estate tax.
And the estate tax, that's after you pass. And before you pass, it's called the gift tax. But the amount is the same.
The amount is the same.
Perfect.
It comes out of the same pot.
So there are tax implications then when you, or could be, when you inherit, when you receive, or when you give, etc. So
and if there are going to be tax implications, then you're going to want to have more sophisticated estate planning documents like generation skipping trusts, revocable trusts, and things of that nature.
Right.
And that's not my specialty. My clients don't usually have those issues.
Okay. You want to add something, Ruth?
Yes, and then I just wanted to ask our attorney to really address, as you're building wealth, what are the key factors of, okay, it's time to create a trust. What are those key factors so that, people know or have in mind, it's time. I should be, getting on this already.
I think the moment the triggers for starting a trust would be you either own property, you purchase property, or you have children. Because we're all going to, continue to succeed, God willing, as we go through life. So the only thing that you need to, you don't need to have a lot of money to have a trust, because once you have a trust, you can continue to put things into the trust as you receive them, your 401ks, etc. All of that will manifest itself as a result of you becoming successful. But the minute you have a house or a child, you want something in place to protect those assets.
Now, let me address something that I think it's important. We are basically saying you have to go to an attorney, but according to the law, you don't have to go to an attorney if you want to take a chance with somebody that you think they know or The whole idea is that the documents have to be notarized, and which is what gives validity to it and what an attorney gives that validity to it.
There's certain elements that every will and trust must have, and those are by statute.
Okay.
But essentially, it has to be typewritten. It has to have 2 witnesses. And you have to attest that you're of sound mind and body. And notarized is not a requirement, but it's helpful because the court will say that it doesn't need any other proof of validity.
Right.
It's a self-validating will if it's notarized.
Revocable versus irrevocable trust.
So irrevocable trust is what anyone would want to have if they want power over their finances. Now, if you're a multi-millionaire, a revocable trust means you can't access that in your lifetime again. So you put $10 million in a revocable trust, and you can no longer access.
While
that money.
you are alive, you don't have access.
But you
to
do that for tax purposes.
Oh, okay. So basically, that would be a bucket with a lid, without a lid.
No, that'll be a bucket with a lid, it's got tape around it.
I have to go back and address when he was talking about how his fees range, right? From how much time he has to spend getting the information together for you. And so I want to encourage the audience to go ahead. You can walk through your home and make a list of things. Make it easier for the professionals that are helping you. And it seems like it's tedious, but it's going to save you money in the long run. So reflect on your life. You want to address that?
Yes, absolutely. When you're going through and you're saying, what do I need to bring to my estate planner? I always say the most important thing are properties and accounts. I don't ever want to see a list of I want Susie to get the ring and I want Eddie to get the because that's I will give you as part of your estate plan what's called a personal property memorandum that has a lot of lines, and you can say who gets what, because you can change that all the time, and it doesn't behoove you to call me and say, hey, I got in a fight with my cousin, I don't want her to get this jewelry anymore. So furniture and jewelry is going to be on you. You're going to dispose of that. I also ask my clients to think of other things that they want, such as, what do you want your funeral to look like? What psalms do you want read? What songs do you want played when your funeral? How do you want it to look like?
Cremation,
burial. How do you? What are the means you want to be kept alive? So those are sometimes the more difficult questions. And lastly, also know it's going to be very difficult if you die and no one knows how to get into your account passwords. So I always ask my clients to make a list of their, not for me, but just I give them just a list, a sheet of paper. They can put, for Bank of America, this is my username, this is my password, because that sometimes are the missing pieces of the puzzle that are the most difficult to get.
And again, estate plan includes medical and financial. We focus today on the financial. We have just 30 seconds, Lupe. Anything that you want to add, recommend to the audience?
That don't let time pass. Young families are young, and hopefully they have a long life ahead of them, but you never know when tragedy can strike. And I think that when we were young, I was just astounded that he said it has to be typewritten, because when we couldn't afford a will, I wrote one, by hand. And for many years that was, and then we finally decided, no, we should be able to afford a will.
There is what's called a holographic will, which is completely handwritten. That is valid, but that doesn't have to have witnesses. That's just...
Got it. Okay, we have come to the end of our show.
Thing.
Thank you, Lupe. I want to thank Attorney Alejandro Perez. Thank you so much. Lupe Solis, thank you so much for making time to be with us. Elaine, thanks so much. We basically... recently met, and I'm so glad you were able to come to our show.
So much
thank
for
you.
having me.
And Ruth, thank you so much, financial advisor for Trilogy Financial Services. Thank you for coming.
Thank you for having me.
And thanks to all of you. This was AARP, Arizona Hispanic Connection. We trust you enjoy the show. Have a great week.